Morning, Your Honor. Edward Autry for the appellant Rosanne Feltus. I'd like to reserve 3 minutes for rebuttal, Your Honor.
3 minutes, all right.
Your Honor, the facts are pretty detailed.
Need to introduce yourself.
Yes.
Oh, I'm sorry.
I did, Your Honor, but I'll do it again. It's
Okay.
Edward Autry on behalf of the appellant
Okay,
Rosanne
thank you.
Feltus, Your Honor, and reserve 3 minutes for rebuttal. Your Honor, the facts are pretty long in this one, but it starts, really, the genesis starts with the creation of 2 irrevocable life insurance trusts in 1998 by a husband and a wife. You fast forward, there was a divorce. Part of the MDA called for the transfer or termination of these trusts to the wife. Unfortunately, the trustee and the qualified beneficiaries of each respective trust were not made parties to that divorce proceeding by the divorce lawyer. So a suit was filed naming the trustee as well as the qualified beneficiaries in a circuit court proceeding, which the court can see in the record the complete copies of all the pleadings, to essentially force the relief that was granted or called for, agreed upon by the husband and the wife in the MDA, which was simply the termination of each irrevocable trust and the conveyance of the underlying trust assets, which were 2 respective life insurance policies, to the wife, in this case, the appellant Rosanne Feltus. For reasons that quite are unknown, other than one sentence that the appellee offered in an affidavit filed August the 20th of 2021, he said he was made aware that one of the children did not agree to the relief and moved to set aside the default order that had been granted against him, contemporaneous at the time that a default order had been entered against the very child that he complained against. When that order was set aside, the default order in the circuit court proceedings, then what transpired was, and he denied that the appellant was required or entitled to any relief, that the trust should not be terminated. A suit was filed in the Chancery Court, which is the subject matter of today's appeal. And again, in that Chancery matter, the dynamic changed, the same relief was requested, but this time we had finally received the final signature to a non-judicial settlement agreement, a contract. And the contract was agreed upon all interested parties for the exact relief that had been requested and adjudicated in the circuit court proceedings. The reason we're here today, Your Honor, is a summary judgment was granted in favor of the appellant for upwards of almost $200,000 in attorney's fees for defending the enforcement of the settlement agreement. And so what we're asking the court to do today is really vacate that summary judgment order and the subsequent December 9, 2024 order on the writ of inquiry and remand it for further proceedings. Now, candidly, there was no discovery allowed by the trial court at all in this proceeding. And so the appellant was without any ability to defend herself against the breach of contract claim by the appellant, which formed the trial court's basis for adjudicating the damages against the appellant. And so what we're asking for is for the court to vacate that. I don't know that I need to bore this court with the standard for summary judgment, but the question is, was there disputed facts at the trial court level? We submit that there was, and that is irrespective of our inability to conduct any discovery.
Mr. Autry, let me ask you a question. I want to back up to something you said. You said you were asking this court to vacate the summary judgment order and I believe the December 9 order and
Correct.
Remand the case.
Yes, Your Honor.
Remand the case specifically for what?
For, candidly, a trial, a discovery, to allow the appellant to engage in discovery of the appellee to garner evidence to support her defenses, estoppel, latches, failure to mitigate damage in defense of the claim asserted by the appellee.
What specifically do you allege was an abuse of the trial court's discretion in regard to your discovery request that was denied?
Well, the abuse of discretion, candidly, Your Honor, was not allowing any discovery whatsoever. We were thwarted at every effort. We propounded interrogatories, requests for production of documents. We noticed the appellee for a deposition. We filed motions to compel. We filed Rule 11 motions for sanctions for failure to cooperate in discovery. We tried every avenue that we could try to conduct and engage in discovery to candidly discover why the appellee chose what he chose to do with the circuit court proceedings. And then we tried every which way we could do to engage in discovery to garner evidence to support the appellant's defenses to the appellant.
So what is the materiality of all that information? I'm not, you'll need to connect the dots for me. I don't understand what the material disputed facts are. What are the material disputed facts?
The material disputed facts, Your Honor, are we were not able to garner and ask the appellee, the defendant in this case, evidence of why he chose the actions he chose. In defense, to mount a defense, the appellee found...
So are you saying a material disputed fact is the trustee's intention of setting aside the default in the circuit court case?
That's one, yes, Your Honor.
Why is that material to anything?
Because candidly, had he not moved to set aside the default order in the circuit court proceedings, that's where this litigation should have ended. That's where the line should have been drawn, and this litigation should have ended, and we should not be at this juncture. That's where it should have ended. Further, when we got to the Chancery Court proceeding, the appellant is the one who filed simply an action to enforce the settlement agreement. What we were met with was a counter-complaint for a breach of contract by the appellee against Ms. Feltus. So to answer your question, what are the disputed facts? The disputed facts are we take the position and assert that the facts, to the extent we're able to depose the defendant, the appellee in this case, that he will have no reasonable basis to choose the action that he chose in fighting and generating the fees and the expenses, because...
So are you saying there's no language in the trust documents that require the trustee to act in furtherance of the goals of the trust?
No, I'm not saying that at all, Your Honor. What I'm saying is...
Wouldn't that, couldn't the trustee always just point to, hey, my trust documents, I'm the trustee of these two trusts, and the trust documents require, as well as the trust code, impose certain duties on me. I'm fulfilling my duty. End of story. So where does that take us on the summary judgment on the breach of the settlement agreement?
Well, you're exactly right, Your Honor. The trustee can take that position, and candidly, that's what he asserted. And we assert that because all the beneficiaries, qualified beneficiaries, were properly before the court and had asked and requested that that action not be taken, that he did it contrary to his obligations.
Is there something about these settlement agreements that aren't self-effectuating? Why is it necessary to get the court's intervention here? Why does the court have to be involved when you have a settlement agreement?
That's a great question, Your Honor, and candidly...
Well, I'm asking about your intention of filing the suits. I appreciate on the first one, you're trying to get signatures.
Yes.
Makes some sense.
Yes, sir.
The Chancery action, though, you have fully executed settlement agreements. So what do you need a court to do with the settlement agreements?
I need the court to enforce it, because the reason that Chancery could...
So you had, before the suit was filed, you had a response from the trustee saying, I don't care what these settlement agreements say that I signed, I'm not going to perform.
Yes, Your Honor. In the circuit court proceeding, he had filed an answer, I think it was in July of 2020, that...
Well, in the circuit court proceeding, I think you would agree that the trustee would be justified in not performing under a settlement agreement that wasn't fully executed.
Well, the circuit court proceeding, candidly, was about, the subject matter was an MDA, not the settlement agreements. But the reason the Chancery court proceeding was filed, in response to Your Honor's question, was the trustee had denied that the
So you
appellant.
had a refusal from the trustee before the chancery action was filed?
Yes, we had a refusal that the appellant was entitled to any relief, was not entitled. He effectively took the position in his answer, filed in the circuit court proceeding, at the time he had already
Well,
signed.
I'm asking about the chancery court proceeding. Once you had fully executed settlement agreements, you're
Yes, sir.
saying in the answer, the trustee denied that the settlement agreements were
That's correct.
enforceable?
He denied it in his answer in the chancery court proceedings, and that answer was never amended, which we pointed out in the record. And he also denied it in the circuit court proceeding. Because if the court doesn't agree with me that this litigation should have ended with the circuit court proceedings, it most certainly should have ended the day the chancery court matter was filed and served upon the appellee, because at that time, attached to the complaint were properly executed non-judicial settlement agreements, executed and notarized, that, again, much like the circuit
And the
court.
trustee was advised of that fact before the chancery court proceeding was filed?
I don't think so, Your Honor,
Well, why not?
because he'd already taken the position that, that she was not entitled to any relief at contemporaneous. He'd already signed.
I mean, I'm not a trust lawyer. So, I mean, it seems to me, the most direct approach would say, hey, trustee, we have fully executed settlement agreements now. Let's wrap these trusts up.
Well, candidly, Your Honor, I would like to ask the trustee that question, but we were prevented from asking him that question. When did he know? Because he may have known. He very well could have known, because the hitch or the impediment during this entire proceeding, both the circuit and the chancery court proceeding, is the request for attorney's fees that has grown from, you can see in the appellee's affidavit, from $21,000 to now approaching $200,000 just to terminate 2 irrevocable trusts.
But the relief you're asking for almost guarantees more attorney's fees for both sides.
Not necessarily, Your Honor.
Okay.
I'm out of time. I'm happy to answer any questions. Thank you, Your Honor.
Good morning, Your Honors. May it please the court, my name is John Woods, and along with my co-counsel Kenan Allen, we represent the appellee Douglas Wright in this case. Beneficiaries of non-judicial settlement agreements are not exempt from their statutory and contractual obligations to reimburse trustees for their reasonable expenses and to honor their obligations not to hold harmless the trustee during the course of his actions. Rosanne Feltus, the appellant in this case, twice sued Mr. Wright, the trustee, for enforcement of settlement agreements, which at the time Mr. Wright was unaware that they were signed. To your point, Judge McBrayer. The first time she sued in circuit court, well, let me back up. In 2017, these agreements were first offered by the appellant, Ms. Feltus, to Mr. Wright. The parties signed them in the summer of 2017, but the other necessary parties to execute these agreements didn't sign them. So for 3 years, this languished, with the settlement agreements being partially executed and out there. And then, for the first time in 2019, Ms. Feltus sues Mr. Wright for enforcement of these settlement agreements, which were unsigned. She did not offer these settlement agreements to him as they're signed. That was not what happened. Then she sued him a second time in Chancery Court. And mind you, she sued him a second time in Chancery Court before she even dismissed the circuit court complaint. Mr. Wright was first aware of the fully executed non-judicial settlement agreements for the first time with service of the Chancery Court complaint. I felt like I was listening to us litigate new facts up here that aren't in the record when my colleague wanted to argue that, well, there was some prior demand that had been made on Mr. Wright, and that's just patently untrue, and there's no support for that in the record whatsoever. The first time that Mr. Wright received a copy of the fully executed settlement agreement, non-judicial settlement agreement, was with service of the complaint after it was filed. In response, less than a week later after service, On November 20th of 2020, Mr. Wright, through counsel, responded and said, here's our fees and expenses incurred in the circuit court action in which you sued Mr. Wright. We'd like these paid. And at every step of the way since then, the appellant has refused to pay those reasonably incurred fees. At every step of the way, the appellant has chosen exorbitant litigation, unnecessary discovery. You heard it up here, about no material facts whatsoever, just exorbitantly expensive discovery, depositions of Mr. Wright. All of these, and accounting was waived in the non-judicial settlement agreements. This was all outside the scope of the non-judicial settlement agreements and enforcing them. And the trial court recognized this. And at every step of the way, the trial court sided with Mr. Wright and against Ms. Feltus, and this court should affirm the trial court in all respects. First, although this wasn't raised in questionings with the appellant, but it's our position that the court has jurisdiction over the entire underlying matter, not just the summary judgment order, not just the writ of inquiry order, but also the order that the court termed itself the final order that was entered on January 17, 2025 after the notice of appeal was taken. I'm happy to address questions on that if the court wants, but otherwise I'm just going to let that sit there. Secondly, the trial court properly denied discovery in this case. I want to be very clear, the trial court properly denied it. The answers, the interrogatories propounded by the appellant were numerous, were legion in number, and they all got to the issue of an accounting. At no point is an accounting relevant to the question of whether Feltus breached her agreement under the non-judicial settlement agreements. That was not at all relevant to the underlying action. And the trial court recognized this and properly granted a protective order to Mr. Wright.
When you say that it was not relevant as to whether that Ms. Feltus had breached her agreement, you're talking there about the agreement to compensate the trustee?
Correct, to compensate the trustee and to hold the trustee harmless and not sue him twice. Keep in mind, before Mr. Wright was asked to honor the non-judicial settlement agreements, Ms. Feltus had already breached them. They were both effective before the Chancery Court lawsuit, and she sued him nonetheless. She had a present duty at the time that she filed the Chancery Court lawsuit to hold Mr. Wright harmless. Without making a demand to honor the agreements, she just simply sued him. Now, to my colleague on the other side's point about the demands that were made early in the litigation by Mr. Wright, there was a legitimate question that Mr. Wright and his counsel had with whether those agreements were in fact duly signed by the persons who they appeared to be signed by. Keep in mind, the agreements were first offered by Ms. Feltus back in 2017 and remained unsigned for a period of years. Ms. Feltus had already attempted to force the compliance with those non-judicial settlement agreements in 2019 in the circuit court lawsuit without being able to turn over the signatures of the contingent beneficiaries and the other beneficiaries of the settlement agreements, or I'm sorry, of the trusts. And during the course of that lawsuit, Mr. Wright became aware, and this is in the record, that Mr. Wright became aware that at least one of the contingent beneficiaries, the sons, one of Ms. Wright's sons, I'm sorry, Ms. Feltus's sons, did not agree to that at that time. So when he got notice for the very first time of these non-judicial settlement agreements being fully executed, he had a reasonable duty to protect the interests of those other beneficiaries by asking, hey, where's the evidence they signed this? I see it here, but you've been offering this for years now. I'd like to see, where's the email? What documentation do you have? Can we talk to them? And that was refused. Now, eventually, Mr. Wright got the documentation he needed and offered to turn this over. At the time of summary judgment, there was no dispute. I want to be very clear. At the time of summary judgment, there was no dispute that these settlement agreements were valid, they were fully executed, and that Mr. Wright wanted to turn over the trusts to Ms. Feltus. He just wanted to be paid for all the litigation that she had caused him to incur. And she has refused it every step of the way. So I think there are two issues here. One is whether the discovery was properly denied. And I think that's, as Judge McGee recognized, was on the basis of an abuse of discretion standard. I think it's clear that there were no facts in dispute. I think Mr. Autry, in fact, even admitted that to the trial court. The trial court asked, "The facts are essentially agreed?" Mr. Autry answered, "Yes, Your Honor. So I think that all the questions that need resolution lie within the sound discretion of this court regarding legal issues." And that's from volume 10 of the record, page 39, lines 23. There was no dispute as to the facts in this case. There was no need for discovery. Ms. Feltus asked in a Rule 5607 affidavit for additional discovery at the time summary judgment was filed, but Ms. Feltus didn't sign the affidavit as is required under the rule. Mr. Autry signed an affidavit, and the affidavit was a small portion of the overall filing. And at no point did it identify, much as Judge McBrayer realized, at no point did it identify material facts that she needed discovery on to dispute in summary judgment. It just said, we need discovery, and that was it. The same discovery she'd been requesting and had been denied previously. The trial court simply didn't abuse its discretion in refusing to grant broad, sweeping fishing expeditions into the entire 20-something year history of the trust. The trial court absolutely did not abuse its discretion. So at the time that summary judgment was granted, the facts were undisputed, and the only issue before the court, which the trial court correctly found, was that Ms. Feltus breached her obligations under the non-judicial settlement agreement to hold Mr. Wright harmless and to pay him his fees that he incurred in the administration of the trusts. Those are the only two issues, and they're plain on the face of the record. She had an obligation that was effective at the time the Chancery Court lawsuit was filed, certainly, and she sued him anyway.
So the trustee was awarded fees and expenses both for the Chancery Court case and the Circuit Court case, correct?
Correct, Your Honor.
And the trustee was awarded fees and expenses for the Circuit Court case under the authority of the settlement agreements that had been fully executed.
I'm sorry, ask that question one more time.
The court awarded the trustee his fees and expenses associated with the Circuit Court case under the authority of the settlement agreements?
I think it awarded his Circuit Court fees under the non-judicial settlement agreement, the trust terms themselves, and in the alternative also under the Tennessee Uniform Trust Code.
Okay, well, so that's what I was getting to. I was a little confused about how a court could award fees and expenses for a matter that predated the effective date of the settlement agreements. And you're saying part of the award was under the authority of the trust code and under the trust documents. So that's where I look to for the provisions for attorney's fees for the Circuit Court case.
Yes, Your Honor. I think you certainly, I think it's true that the trial court relied on the trust documents and the Uniform Trust Code in awarding the Circuit Court fees. I think it is equally valid to have looked only to the non-judicial settlement agreements for an award of those fees as well. Under the terms of the non-judicial settlement agreement, it clearly states that that the trustee will be compensated his fees and expenses incurred for administration of the trust. In the Circuit Court lawsuit, Mr. Wright, the trustee, was defending the interests of the beneficiaries against Ms. Feltus's baseless lawsuit. So he properly incurred those fees in the Circuit Court matter in administration of the trust, and under the terms of the non-judicial settlement agreement, she owed him those fees and expenses. And I think that's equally true under the trust code as well, Your Honor.
So are you saying that Ms. Feltus had no right to question the amount of the fees that were being charged then?
I think it is a true statement that Ms. Feltus waived her right to an accounting under the non-judicial settlement agreement. So she certainly waived her right to an accounting, yes. And she didn't dispute the reasonableness of those fees. She disputed that she owed them at all.
Okay.
So when the second component of this hearing came on to be heard, Ms. Feltus never argued, wait, there's no proof of reasonableness here, or I don't believe these fees are reasonable?
So in appellant's briefing,
Well, let me Before you answer that question, let me step back and answer. So did Ms. Feltus request a hearing, an evidentiary hearing on the fee request?
At the writ of inquiry hearing, no, Your Honor. There was no proof put on, affidavits to the contrary. We, of course, had the affidavit of Mr. Allen of counsel for Mr. Wright. I think even Mr. Wright filed an affidavit himself, although don't hold me to that. I could be mistaken on whether he filed an affidavit at that time. But we put on proof. The court went through the Rule 1.5 assessment and for reasonableness of fees, and there was no contrary proof put into the record at the writ of inquiry order. No, there was not, or at any time subsequent to that, Your Honor.
But no request for an evidentiary hearing by Ms. Feltus?
No. Sure, I think that the decision of the trial court, again, which is, I think, viewed on for the purposes of a request for discovery, an abuse of discretion is just clearly falls in the appellee's favor here. The trial court absolutely did not abuse its discretion. It was entirely within its discretion to deny discovery. And on the facts, they're playing before this court as well. And she had an obligation under the non-judicial settlement agreement to not sue, and she sued. That's all there is to it. And that the history of this case is not that long. I mean, it's long, but it's not that hard. She had an obligation not to sue, and she sued. That's the summation of this.
Let me ask you this.
Yes, Your Honor.
I've read your briefs, but I haven't been through the record. Is there in the record anything on behalf of the trustee to itemize fees, to break down the fees, to say, here's why it's so much, here's why I'm asking for what I'm asking, here's what I claim was attributable to the circuit court, here's what I claim is attributable to the chancery court? Has all that information been put out in the record?
In a word, yes. Yes, it's in multiple pleadings, sort of a narrative of why these fees were incurred is in a narrative form in several of the pleadings. It's also in our briefing to some extent, Your Honor. Our attorney's fees are certainly attached to the affidavits and request for an award of fees. So all of that is in the record, Your Honor.
And the settlement agreements didn't have any carve-outs for enforcement of the agreement on the attorney's fees or hold harmless provision? I mean, sometimes in these agreements, you'll see a provision that says, we're going to hold you harmless, and yes, you refuse to comply with the agreement, and so we can sue in that context.
I don't believe, as I say in here, I don't want to swear to it, Your Honor, but I do not recall a carve-out in this particular instance. With that, I see I have 2 seconds, so I just ask that you affirm the trial court in all respects. Thank you.
Thank you.
Your Honor, with all due respect to my colleague, I think he misunderstands the application of the non-judicial settlement agreements. The hold harmless has no application to what my colleague requests. What the hold harmless was intended to read, and it's paragraph 4 of each non-judicial settlement agreement, talks about, and I'm paraphrasing, any matters with respect to the administration of the trust. This is not an administration of the trust.
So why would your client need all the trust records going back years then?
That's a great question, Your Honor, because the disputed issues were he was entitled to fees consistent with prior practices relating to the management of the trust. That was the benchmark upon which he was entitled to request fees under the non-judicial settlement agreement. We were simply asking, contrary to what my colleague has asserted, we just want to know what was the prior practices. What were you paid in the prior?
So there's an interrogatory asking what were the prior practices for
Yes,
payment of attorney's fees?
for both trusts. Yes, Your Honor. And that was the disputed issues, because you asked what the disputed issues were. Keep in mind, when the Chancery Court proceeding was filed simply for the enforcement, the appellee responded, filed an answer, and denied that the settlement agreements were valid. He denied it. So that was a disputed fact. That, remember, he never filed an amended answer. He never changed his position. So that was one disputed question. Were they enforceable? Number 2, what were the prior practices of each trust? Number 4, when was a statement submitted by the appellee? Because I know this court has repeatedly gone through and talked about what is actual evidence. And I know this court knows you can't just simply attach an email to a pleading and claim that is evidence. When Your Honor gets a chance to go back and look at the technical record, I ask you to really look at what is actual evidence in this case. And I would submit it is, there's several volumes to this case, multiple volumes. But the only evidence in this case is the affidavit from Doug Wright, an affidavit from his counsel, and our verified complaint. There is no other evidence. There's no evidence of this statement. It's an email from his counsel attached as an exhibit to a motion. That is what they're claiming the evidence is in this statement. But when you go back and look at the hold harmless, it's the administration of the trust to date, and further, the actions contemplated under the terms of this agreement, which is simply the termination of the irrevocable trust, which the beneficiaries had an interest in, money. That's what was contemplated. It did not require or prohibit her from filing suit. Remember, in the context of where we're at, the appellee had already denied these were valid, had already denied that she was entitled to any relief. She just wanted enforcement of the settlement agreement. That's all she asked for, and candidly, the day that suit was filed is the day it should have ended. Instead, he countersued 10 days later. Happy to answer any questions, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you, counsel. We will take this matter under advisement and attempt to get you an opinion at the earliest possible time.